Share screen. All right. Okay. So from last time, we discussed the different circumstances which exempt a person from criminal liability. We discussed paragraph 1 thereof, which is the imbecile or insane person. We all know that an imbecile or insane person is exempt from criminal liability. However, he will not be liable when he acted during a lucid interval. So please don't forget the first exempting circumstance when it comes to circumstances which exempt a person from criminal liability. Now, the second um, available circumstance which exempts an individual from criminal liability is minority. Now, if you look at your revised penal code, you have paragraphs 2 and 3 there. Now, this has already been amended pursuant to Republic Act 9344 or your Juvenile Justice Welfare Act of 2006. So do not base your arguments or legal basis under Article 12, 2 and 3, but you should answer the provisions under Republic Act 9344 because that is Republic Act which supplements exemption of minors from criminal liability. Now, minority, we all know that minority means childhood, parang teenage years, parang bata pa ka. So why does the law exempt a minor from criminal liability? The basic answer there is that it's simple. Children do not know what the consequences of their actions are. And at the same time, they do not know if such actions are right or wrong. Now, under Republic Act 9344, Section 1, this act shall be known as the Juvenile Justice and Welfare Act of 2006. Please do not forget this because this has already come out several times during the board exam. So commit into your memory, starting now, all the special laws surrounding our jurisdiction. So you should commit into memory RA 9344 or your Juvenile Justice and Welfare Act of 2006. Now, under Section 2 thereof, it is the state policy, it is the policy of the state to observe the following. I only included here the important provisions under RA 9344 because the rest, Manggod, will have no idea about it because Republic 9344 is much more linked towards the work of the DSWD. It's just up to us to know that pursuant to 9344, minors will really benefit from the exemption of being not liable for criminal liability. Now, under Section 2, it is the observance of the state to recognize the vital role of children and youth in nation building and shall promote and protect their physical, moral, spiritual, intellectual, and social well-being. In short, the state must protect the holistic approach of the child because the state recognizes that the children are our future. That's why we have to protect them at all times. Plus, it is the role of the state to be the parents or the substitute parents of these children. That is why we have this principle, parents patriae, which means the state acts as the parents of the children. When you say parents patriae, it's spelled as PARENS space PATRIAE. So it's parents patriae. Now, you have also here on the second part, which states that the state shall protect the best interests of the child. Now, this phrase, protect the best interests of the child, has been repeatedly um, uh, placed in provisions, has been placed in several landmark decisions of the Supreme Court, because the ultimate goal of the state is to always protect the best interests of the child, meaning it has to observe certain standards in order for it to protect the child and his growth. Now, on the third one, the state shall apply the principles of restorative justice in all its laws, policies, and programs applicable to children in conflict with the law. Why restorative justice? Because the state recognizes the child has the capacity to be restored to his former self, and to prevent further harm, the state should take into custody these children in conflict with the law, so that they would become full-grown, responsible adults in the future. So that's why we don't put them into jail. Actually, we do not put them into jail. We put them under intervention programs, or programs which are akma to the sustenance of children. So that's why we focus on restorative justice when it pertains to children in conflict with the law, because we want them to be, we want to cure them. We want to make sure that they become better adults when they grow up. All of these may be found under Republic Act 1944. Hagi, explain lang yun now kung sa ito mga important provisions. Now, as to definition of terms, under 9344, yeah, mura na siyang best interest of the child. It means totality of circumstances and conditions which are most congenial or most akba, that would be applicable, or at the least, it will be provided for the survival, protection, and feelings of security of the child, and most encouraging to the child's physical, psychological, and emotional development. So see, ang best interest of the child is a holistic approach. When you say holistic approach, totality yun ba ang bangka sa law, which is physical, psychological, and emotional development. All in all, gusto sa balaod i-protect and i-improve ang development sa child, not just physically, not just emotionally, but also psychologically. Now, under 9344, a child refers to a person under the age of 18 years old. Now, I want you to cross-reference this to what is a child under Republic Act 7610. Now, under Republic Act 7610, a child may refer to a person below 18 years of age, or those over but are unable to fully take care of themselves or protect themselves from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition. Hence, kung ibuklod ni mo ning duha ka provisions, that's why I'm naiingon ko to give me time to prepare for this, because I have to cross-reference a lot of laws para malinyada na to kung unsa ang definition sa child. So in our jurisdiction, a child is considered a person under the age of 18, and at the same time, those who are unable to fully take care of themselves or protect themselves from abuse due to discrimination because of a physical or mental disability or condition. So, mauna ang definition sa child. Now, under 9344, a child at risk is a child who is vulnerable to and at the risk of committing criminal offenses because of personal, family and social circumstances. Now, what are examples of children at risk? If you have parents who are into drugs, then most likely they will be vulnerable to be open at that scenario. They will also perhaps be inclined into doing such thing because their parents are doing it. So these are considered children at risk. Now, when you say child in conflict with the law or your CICN, it refers to a child who is alleged as, accused of, or adjudged as having committed an offense under Philippine laws. So, in short, if a child commits a crime, an offense, or a violation, then he is considered as against any of the Philippine laws, then he is considered as, or he or she is considered as a CICN, or a child in conflict with the law. Any questions so far?
No, sir.
None, all right. Now, very important provision under your section 6, under your 9344 is section 6 of Republic Act 9344. Please, ayan nyo, i-delete lang ninyo ng RA 116481. Just focus on section 6 of RA 9344. Now, under section 6 of RA 9344, a child 15 years of age or under, meaning 15 and below, at the time of the commission of the offense, shall be exempt from criminal liability. The word there is shall. Absolutely, he is exempted from criminal liability. However, if a child above 15 years of age but below 18 years of age shall likewise be exempt from criminal liability unless he or she has acted with discernment. So that is what you call a conditional exemption. Because for you to be criminally liable, if you are between 15 to 18, you must have acted with discernment. Now, what do you mean by discernment? Later na lang. Naklaro ang absolute exemption and conditional exemption. Naklaro, class?
Yes, sir.
Okay.
Yes, sir.
Now, how do you determine the age of a child? So, a child's age may be determined through his birth certificate, baptismal certificate, or any other pertinent documents. In the absence of these documents, you may introduce secondary evidence, such as you ask the child from himself, how old is he or she. You may also ask testimonies from other persons. You may look at the physical appearance of the child and other relevant evidence in order to obtain at least to determine the age of a child. Now, we have this practice here na, for example, I'll give you an example sa case na mo ha. We caught an individual who kanang gimol nila ang isa katao ba? Gang sila, gimol nila ang isa kalalaki. Now, kaning mga gang, they raise the defense of minority. Kanya, pagtala naman silang birth certificate, alanganin kayo mga di man may musugot na minor pa rin sila kay kung talawon mo sila ang mga now murag ni pass over na sila sa 18 ba. So di ba pag mo raise kag defense of minority, ang presumption man gyud di ba, it must be in favor of the child. So as prosecutor, ingon ko, why don't we explore other interventions wherein we can really determine the age of these respondents. So gibuhat na mo is may balaan mo nimo na no sa we have a new technique now kanang may balaan nimo through through dental na procedure kung pila ang edad sa bata. So mao na karon pag in doubt mi ang prosecution sa age sa child, ginapacheck na mo ang iyahang dental, basta na something, dentist ang bahala ana para mo tanaw whether or not he already is still a minor or not. Okay. So what happens if a child below the age of criminal responsibility is caught? So what happens here is that the authority will have to make an initial contact with the child and has the duty to immediately release the child to the custody of his or her parents or guardian, or in the absence thereof, the child's nearest relative. So this also happened to us. A minor child, 12 years old, was caught stealing. So automatic, he's exempt from criminal liability because of absolute exemption. Plus, the authorities, DSWD and PNP, i-instruct na mo sila to return the child to his or her parents. Or if not to her parents or guardian or nearest relative. Na ang mando under Section 20. Now, what happens if, let's say, you committed an offense or a crime at the age of 16 and you acted with discernment, and sa kadugay sa imong kaso ni abtan na kag 19 years of age, what will happen? Makulong ba kaana or will there be still a valid defense of minority on your part? Of course, there will still be a valid defense of minority on your part because at the time you perform the act or the criminal act, diha man mag-determine, diha man ta magtanaw kung unsa ang age nimo sa pagbuhat nimo ana ng krimen. So if you acted with discernment at the age of 16, then 16 ta mag-count. So if nagdugay ka sa prisohan, after kag 19 years of age due to sa kadugay sa mong kaso, do not worry because the law will still be in favor of you. Kasi may tabo, there will still be an automatic suspension of sentence. So, if you were found guilty, na let's say minor ka, you were found guilty, and let's say na ay penalty sa imuha na, let's say prison mayor or more than 6 years na penalty, then masuspend ang imuhang sentensya. Meaning, it will be suspended, hindi ka ma-adto sa jail, but instead, you will be directed to join the intervention program as provided for the court. When you say intervention program, kanang mga activities, daily activities na ipabuhat sa imuha kay para ma-prepare ka to be ma-prepare ang child to be reintegrated back into society. So the child will not be detained in the jail. So for example, 16 ka, nabot na 19 years of age, ya 19 gipatulan ka, gi-sentensyahan ka prison mayor, masuspend gihapon imong sentensya because ibuhat mo nimo ang krimen at the age of 16. So pabor gyapon ang balaod para sa inyo. Any questions so far?
Sir,
Ah,
what if sir kung
Sir, excuse me, sir.
ibalik-balik ang krimen niya gibuhat sa bata?
okay, balik-balik. Balik-balik muna to siya na actually that happened. Good question, Mr. Orculio. That happened here in Baganga. So at that time, he was still a minor. So he enjoyed the valid defense of minority. So pirmi na mo dismiss ang case and refer to DSWD for intervention program. So naabtan man na siya age of majority. Kay this time, robbery na siya. But I, together with the PAW, we discussed that there is really something wrong with the child because when we talk to him, he does not talk na kanang murag normal good. Na ay, makita gid mo naging problema aning bata-ana ni. So what we did was we asked from the court to secure him to be sent to SPMC and have him checked. And moto, bago na ako nakita ng result ron, he is not fit to stand for trial because he is mentally retarded. Na-answer ba na ako yung pangutana, Mr.
Sir, excuse me, sir.
Yes.
Okay, sir.
Bitwalya,
Thank
sir,
you.
present.
What?
Bitwalya, sir. Bitwalya, karon pa ko kasulod. Kaya hindi ako internet.
Okay. Mr. Orculio, na-answer ba na ako yung pangutana?
Yes, sir. Thank you, sir.
Sige. Right. So, diba, if you are 15 years of age and below, you are absolutely exempt from criminal liability. But if you are 15 years of age, below 18 years of age, you will also be exempt from criminal liability unless you acted with discernment. So, if you acted with discernment, then you will be held liable for the offense or crime the child has committed. So, unsa man ning discernment? So, according to Attorney Ramil Gabaw in his criminal law book, mental capacity of a minor, discernment means mental capacity of a minor who is over 15 but under 18 years of age to understand the difference between right and wrong and or fully appreciate the consequences of his unlawful act. According to Tolentino and according to Buwado and si Campanilla, mental capacity is a discernment is the mental capacity to understand the difference between right and wrong, and such capacity may be known and should be determined by taking into consideration all the facts and circumstances afforded by the records in each case, the very appearance, the very attitude, the very comportment and behavior of the said minor, not only before and during the commission of the act, but also after and even during the trial. So, mo yung pasabot sa discernment. The capacity to understand the difference between right and wrong and to fully appreciate the consequences of his unlawful act. Hence, if a minor child acted with discernment who is 15 to 18 and below 18 years of age, then he will be criminally liable for such act. Naklaro ang meaning sa discernment?
Yes, sir.
Alright. Now, ning discernment, dili kami ang prosecutors ang nagabuhat ani ha. Dili mi psychologists, but it's the DSWD who will prepare a series of battery of tests that will determine whether or not the child acted with discernment. So, naana sila mga tests, naana sila mga questionnaires na ginahatag sa bata in order for them to assess whether or not the child acted with discernment. Tapos maghimo na sila report kaning social worker kay para ma-inform ni prosecutors whether or not the child acted with or without discernment. All right. So, a very pertinent provision under Republic Act 9344 is Section 58, which means offenses not applicable to children. So, what are these offenses which are not applicable to children, whether they be below 18 years of age? So, according to this provision, persons below 18 years of age shall be exempt from prosecution for the crime of vagrancy and prostitution under Section 202 of the Revised Penal Code, of mendicancy under PD 1563, and sniffing of rugby under PD 1619. The reason why these offenses should not be applicable to children is because they are inconsistent with the United Nations Convention on the Rights of the Child. So, sa maning mga offenses na not applicable to children. So you have here Article 2 of the Revised Penal Code, vagrants and prostitutes. So kinsa man yung mga vagrants? Vagrants are any person having no apparent means of subsistence who has the physical ability to work and who neglects to apply himself or herself to some lawful calling. Meaning, walang-wala ka, pero may capacity ka to work, but you do not work for yourself. Isa pa, any person found loitering about public or semi-public buildings or places, or trampling or wandering about the country or the streets without visible means of support. Kanang mga vagrants, kanang mga, kanang sa Davao good, kanang mga palaboy-laboy, wala sila. Third, any idle or dissolute person who lodges in houses of ill fame, ruffians or pimps, and those who habitually associate with prostitutes. So if you associate yourselves with a prostitute and let's say nagatambay ka sa mga lodge kung naasa na ang mga mamasang, you are considered as a vagrant. And so pa, any person who, not being included in the provisions of other articles of this code, shall be found loitering in any inhabited or inhabited place belonging to another without any lawful or justifiable purpose. Again, another palaboy. Number 5, prostitutes. So these are what you call vagrants and prostitutes. So for purposes of this article, women who, for money or profit, habitually indulge in sexual intercourse or lascivious conduct are deemed to be prostitutes. So kani sila na provision, hindi mo apply for children. So if you see children who are vagrants or prostitutes, then they cannot be held criminally liable because of Section 58 of Republic Act 1944. Hindi mo apply sa ila. Unsa pa? Presidential na pa niya. Presidential Decree 1563 or the Anti-Mendicancy Law. Ano yung mendicancy, sir? When you say mendicant, it refers to any person except those enumerated in Section 4 of this decree who has no visible and legal means of support or lawful employment and who is physically able to work but neglects to apply himself to some lawful calling, instead uses begging as a means of living. In short, kanang sige pangayo, sir, alms for the poor, sir, mga piso, sir, 5, sir. So, mga sila ang mga mendicants. In short, kanang makita niyo sa 7-Eleven diha sa Katiin na sige pangayog 5 o 10 pesos, you cannot hold them liable for mendicancy because these children are again exempted from criminal liability because of Section 58 of Republic Act 1944. So, into mind ha, mendicant, kanang begging, beggars ba? Sige pangayo. Pa, ED 1619 or kanang pag-inhale sa rugby. So you should not hold a child to be criminally liable if simot siya rugby because again of Section 58 of Republic Act 1944. It will not apply to them. Aro? Hello?
Hi, sir.
Hello, sir.
Alright. Sige. Sige ha, let's try to apply what we have learned. So again, minority, there is absolute exemption and there is conditional exemption. Now let's apply it to the case at hand. So let's say this happened. So let's say this happened during the onset of Republic Act 1944 ha. Let's say nigawas na ang Republic Act 1944. Kanya kani ang case na nagatubang sa imuha. As police investigator, what will you do? Any volunteer? Kasangyaw? Where is Mr. Kasangyaw? Mr. Kasangyaw, where are you? Or else I will remove you from the list who are here. Wala si Mr. Kasangyaw? Volunteer. Volunteer?
Sir, anong questions yan, sir?
Sige, let's read the facts.
Okay, sir. A farmer caught the accused 11 years old child shooting at his prized mango tree. Because of this, the farmer reported the incident to the accused parents. Out of revenge, the accused hit the offended party with a slingshot. The accused shouted, "Putang ina mo, mabuti natikman mo."
All right. So
So-
let's say, for example, the offended party suffered slight physical injuries and he wants to file a case against the 11-year-old child. Do you think slight physical injuries will pursue as against the 11-year-old child? Can the 11-year-old child raise the defense of minority in this case?
Yes, sir.
Yes, very good. Because, di ba, you have your
Because-
absolute.
Kasi yung bata, sir, yung side na hindi niya alam yung tama at mali, o yung sinasabing discernment, gutom siya, sir, ng pagkain. Pagkain lang naman yung problema, yung yan naman, sir. So,
Are you sure? Remember, discernment can only be assessed with the aid of social worker. So what if wala kay social worker diha? Based on the law lang, under Republic Act 1944, Section 6, how will you argue?
so according to the law, sir, it is absolutely exempted, sir, because it is below 15 years old.
Very good. So that's how you argue. Huh? So in this case, the 11-year-old child cannot be prosecuted for slight physical injuries because, as provided for Republic Act 1944, Section 6, children below 15 years of age shall be absolutely exempt from criminal liability. Ano ha? But, muna siya, nag-apply ang imong first paragraph.
Yes, sir.
But, this is a true-to-life case. This is a case of People versus Alcabao. But, this happened prior to Republic Act 1944. Now, since it happened prior to Republic Act 1944, nag-apply na allowed is Article 12, Paragraph 2 and 3. Di ba 11 years old to siya? Now, a person over 9 years of age and under 15, unless he has acted with discernment, in which case such a minor shall be proceeded against in accordance with the provisions of Article 80. So in the old law, kumbaga, the old law, na-shoot ang bata sa between 9 years old to 50 years old. Tapos, according to the court, he acted with discernment because he said the following words. He said, "Putang ina mo," which means a perversion on his part. And he said also, "Mabuti na tikman mo," which means his part, he acted with discernment because he is satisfied and elated because he completed the criminal act. Nakaingon mo siya, may gaya, nakatilaw ka sa kuang sa slingshot. So, taken all together, the Supreme Court said, these are acts constituent of discernment. Hence, the 11-year-old child should be criminally liable. But again nahimo siyang criminally liable because wala pa ang Republic Act 9344. It was the previous act or the Article 12, Paragraphs 2 and 3 ang nag-apply. But tama gyapon tong answer nimo, Mr. Sumambot, ha? Just It's just that kaning Nigawas people versus Alcabao prior to the enactment of Republic Act 1944. Right, next. Volunteer to read. Volunteer.
Sir.
Ako, sir.
Volunteer. Wala.
Ako, sir.
Sir Liban,
Sige.
sir.
Sige, liban. Liban. Okay, magkaroon natin ka dunggan. Go ahead.
Sometime in March 1990, Lorne Cortisano decided to take a leave of absence from her part-time jobs in Cubao, Quezon City, to spend her vacation with her 3 children, 8-year-old Leah sir yan,
Ah.
Leah 3-year-old, Leah Lo, and Lionel,
Mm.
who was barely a year old. Lorne decided to stay in the house of her parents-in-law, Santiago and Nita Cortisano. Nita and Santiago slept in a room separated from the sala by a curtain. Their children, the accused, Bernardo or Butchoy Cortisano, who was the 12 years old, the accused Joel Cortisano, who was then only 13. Tinggang, who was 6 years old, and Boyet or Sign, their 6-year-old nephew, also lived in a couple. At night, Lorne and her children, as well as Joel, Bernardo and Tinggang, slept beside each other in a room near the kitchen, beside the couple's room. By mid-April of 1990, Lorne returned to Caloocan City, leaving her children in the care of her parents-in-law. One time, the accused Bernardo and Joel asked Leah to go a certain room in the house. It was the time that both of the accused raped Leah. One was addressing her while the other one was a lookout. Leah was told not to tell anyone about what happened. The incident occurred several times, and subsequently, Leah told her mother that she was raped by both of the accused. The accused were charged and convicted with rape.
Thank you, Mr. Liban. Would you like to answer? Mr. Liban, would you like to answer the question?
Sir, any
Suppose,
questions, yan, sir?
suppose, um, the mother filed a case against Bernardo and Joel for the crime of rape. Can Bernardo and Joel raise the defense of minority if this, let's say, if this happened today with the enactment of Republic Act 1944, would the defense of minority be beneficial for Bernardo and Joel?
Sir, pwede mo sir.
Sige, De Los Santos, go ahead.
Um, according article to sir 9344, the Bernardo and Butchoy will yun sir. Kay baba pa mo sila sir 15 years old below. Wala pa man sila nag 15, si 12 pa man si ano. And 9 si ano Santiago ba to? Diba to? Si Bernardo si ano sir. 12 years old pa sila, so exempted sila sa ano sir.
Okay.
Wala akong try sir.
Okay, good. Actually, yes. If this happened today, together with the enactment of Republic Act 1944, Bernardo and Joel cannot be held criminally liable because they are absolutely exempted from criminal liability as stated under Section 6 of RA 9344, di ba? Because Bernardo is just how old? 13. 12 di ay, whereas Joel is just 13. So, klaro kayo, di ba, na below 15 years of age sila. So, they cannot be held criminally liable for the crime of rape. Thank you, Mr. De Los Santos. Now, what if this happened during the time of wala pa Republic Act 9344?
Sir, recommend, sir.
Okay, go ahead. Go ahead, Recomes.
Sir, dili, sir, kay the accused, sir, do it several times, sir.
Mhm.
Malang, sir.
So, what
Cabrera,
if,
sir.
so what
Ano, sir,
what are you trying to say,
we
Mr.
can
Recomes?
trace the, sir, kay, yeah, ang ingon mo kanina, sir, dili sila maka-raise of, ano sa ito siya? Depends to minority, sir, kay ano, sir, gibalik-balik nila paghimo, sir, several times sila tama ba, sir?
Okay, so when you say balik-balik nila ginabuhat, what does that entail? Very good answer, Mr. Recomes. Kulang lang og justification. Anyone else?
Sir,
Sir, pwede mag-add, sir.
Sir, sumambot, sir.
Layban, sir, pwede mag-add.
Cabrera, sir.
Si, Mr. Cabrera, go ahead.
Sir, pwede pakibalik atong question, sir.
Ibalik ang question. Okay. For example, this scenario happened in the early 1990s and there is still no Republic Act 9344. The question here is, can Bernardo and Joel raise the defense of minority?
No, sir.
Why?
Sir, no, sir.
Sir, because the 93 sir is the only actor na naga-defense sa ilaha, sir, para dili sila mag-guilty, sir. And then kung wala pa to, sir, wala sila yung magamit, sir, para i-defend, sir.
This is the pertinent provision, Mr. Cabrera.
sir, all call you, sir.
Sige daw. Let's say, ang law at that time, wala yung 9344. How will you answer that, Mr. Cabrera?
Sir,
Let's say, wala pa tong Republic Act 9344. Kani ang applicable na balaod at that time. So how will you answer as to the question, can the children raise the defense of minority?
no, sir.
Why?
Because the Republic Act number 9344 section 1, this act shall be known as the Juvenile Justice and Welfare Act of 2006.
No. What
Sir,
if
pwede ako, sir.
wala pa yung 9344? Tapos, kanin siya na scenario na hitabo back in the 1990s and during that time, ang prevailing law kay kanilang Article 12 na na Section 1, 2, and 3. Do you think Joel and Bernardo can claim minority?
9 to 3.
Sir, can I answer, sir?
Mapasa ako, sir.
Sige.
Sir, can I answer, sir?
Tama to yung mong answer ha, initially na if this happened during the current age, meaning kung karon, 9344, then they will be absolutely exempted from criminal liability. But the question is, what if this happened before the enactment of Republic Act 9344 and your available law is only Article 12? So what will be your answer?
Sir.
Kisa man.
All call you, sir.
Arculio, go ahead, Sir
Los
Arculio.
Santos.
Sir, try lang, sir.
Mm.
For me, sir, no, sir, kay discernment maguna siya, sir, niya. Wala, kabalo sila, so what is right or wrong?
Okay, so based you said that they acted with discernment, di ba? Now, asa dire sa facts, makaingon ka na they acted with discernment.
Kuan sir kaning ah ilang giingnan siya sir nga ayaw dili lang magsumbong sir.
Yes, very good. Number
Paulit-ulit
one.
sir.
Unsa pa?
Paulit-ulit sir na ginawa nila sir.
That may be. Unsa pa? Nasa second paragraph.
Kabalo sila sir sa balaod sir nga mali sila sir.
No? Tama na to unsa, tama na tong giingnan nila na ayaw ni iingon because they know that it's morally wrong. So, unsa pa? Klaro kayo sa facts sa second paragraph? Sirit?
Sirit sir.
Look out. Ang isa nag-work as lookout. So kabalo gid sila na mali ilang ginahibuhat. Kaya may lookout. 'Di ba?
Yes sir.
Okay. Anyway, ingana mo itabo sa inyong exam ha kanang kinahanglan gyud niya i basahon tarong ang facts kay para makuha ninyo kung unsa ang ginapangayo sa question or unsa ang ginapangayo sa element sa crime. So according to the Supreme Court, this is the case of People versus Cortesano. According to the court, the accused acted with discernment when they raped the victim because the manner of their acts. First, dahil gitilapan ang vagina using their saliva before gi-rape nila sila. So meaning there is sexual fulfillment on their part ba na, uy, giwet niya ang vagina sa girl. So that means, na sila yung discernment na when they wet a person's vagina, then they are already sexually aroused. So pa, one of them acted as a lookout while the other was raping the victim. So they know na what they are doing is wrong. Kay ang isa nag-lookout man. So kung na mo abot, mo stop dayon sila from doing their deed. Lastly, they threatened to kill the victim if she divulged what happened. So these are all facts that would lead the Supreme Court to decide that the children really acted with discernment. But then again, this is the decision of the Supreme Court prior to the enactment of Republic Act 1944. At that time, manggod, ang available lang na law is Article 12. Na-shoot ning si Joel o si Bernardo sa kanina balaod. Sana to. Na-shoot sila diri ning a person over 9 years of age and under 15 unless they acted with discernment. This is the old law, manggod. Muna ko ginaingon na paragraphs 2 and 3 will no longer apply because na naman tayo Republic Act 1944 today. But previously, kani siya ang law na apply as to minority. So, klaro ta? Naipangutana?
Mas maganda.
Yes, sir.
Alright, sige. So, if a child is found out to be guilty, if found out guilty, or let's say he was caught committing a crime or an offense, then he will be enrolled in an intervention program. So when you say an intervention program, this refers to a series of activities which are designed to address issues that cause the child to commit an offense. We take the form of an individualized treatment program, which may include counseling, skills training, education, and other activities that will enhance his or her psychological, emotional, and psychosocial well-being. So dili na to sila ibutang sa rehas, but instead they will be subjected to an intervention program. So mo lang na siya. And, any question?
No, sir.
Wala. All right, sige. Thank you to those who participated. Those who participated, nagin mo yung points as part of receipt. If labi ako mag-volunteer mo.
Sir, present na ko, sir.
Yes, yes. I-change
Sir
na lang.
Liban, sir, present, sir.
I-change na po na ako.
Thank you, sir. Thank you, sir.
All right, sige. So, any questions so